Asa Houston's supplemental authority in support of motion to dismiss count 4. Yeah, this finna get real interesting. Eyes hurt. So look, I read the Mangione decision, all of it. And before we even touch the Houston argument, I need y'all to lock in because this video is not what you think it is. We're not doing Twitter law. We're not doing vibes. We're doing real federal law. And I'm about to argue both sides of this thing. Here's how this is going to work. So on one side, I'm going to go full prosecution mode. I'm going to tell you exactly how the government wants this to read and why they think stalking should count as a crime of violence and how they're trying to save that to the gun count. Then on the second side, I'm gonna switch sides. Same documents, same law, same facts, but we're gonna go pro defense. And I'm gonna show you why that prosecution argument sounds good and still collapses under Supreme Court precedent. And by the end of this video, we're going to understand something most people online actually don't. This isn't about being scary or being guilty and all these shoot 'em up bang bangs in LA. Supreme Court quietly boxed the government in and why judges are now being forced to throw out count 4. And this count the judge is going to have to. So I'm going to show y'all why the prosecutors are nervous and why the defense lawyers are copying and pasting this argument, why this Mangione decision is going to start popping up everywhere. You got to watch this all the way through, though, because the end flips the entire narrative. So let's start with the government's argument, and then we're going to tear that shit apart. But before we do, hit that QR code, man, so y'all can play games while y'all listening to this, because this is a relatively longer video just to get y'all cracking early in the morning. But hit that QR code and tap the link in the description for free cash. That's $5 on there as soon as you start to happen, get signed up on your phone, and we going to go ahead and get you paid today, man. Hey, only app that's out here that I know of that's paying y'all to play. Free cash, QR code, or tap the link in the description. But other than that, let's go. Defendant Asa Houston respectfully submits this third notice of supplemental authority in further support of his motion to dismiss count 4 of the second superseding indictment. This notice brings to the court attention a recent district court decision, United States versus Mangione, January 30th, 2026, which analyzes the same stalking statute charge, in this case 18 U.S.C. 2261A1A, and holds that offenses charged under that provision are not crimes of violence as a matter of law. A copy of the order is attached. 1. Mangione addresses the exact statute at issue here, 18 U.S.C. 2261A1A. In Mangione, the district court considered whether stalking offenses charged under that damn thing, I'm not going to say it again, could qualify as crimes of violence for purposes of 924C predicate. That is the identical statutory provision underlying count 4 of Mr. Houston's indictment. After extensive analysis, the Mangione court held that stalking offenses charged under that cannot satisfy the elements clause and therefore cannot support a crime of violence designation as a matter of law. Mangione confirms that 2261A1A fails the elements clause requirement for multiple independent reasons. The Mangione court holding rests on several conclusions, each of which independently supports dismissal of count 4 here. First, the court concluded that the federal stalking statute is divisible into 4 distinct crimes, and that the modified categorical approach therefore applies Mangione slip-up at 12 through 18, even applying the more government-friendly framework. However, the court held that none of the charged stalking offenses necessarily requires proof that the use, attempted use, or threatened use of physical force as defined by the Supreme Court. Second, the court emphasized that the only statutory element that could even potentially satisfy the elements clause standard can be committed with a reckless mens rea, which is categorically insufficient after Borden versus United States. As the court explained, because 2261A permits conviction where the defendant does not act with purposeful or knowing intent to use force, the statute fails the elements clause as a matter of law. The defense is trying to sell here something that sounds smart on paper but collapses the second you apply real world logic. They're waving around the Mangione case like it's the damn Constitution. It's not. It's a single district court opinion from New York, not the Supreme Court, not controlling precedent, not binding on anybody outside that courtroom in particular. So the idea that one judge's opinion magically wipes out federal stalking as a crime of violence nationwide, man, stop that. It's cherry picking at its finest. Now, let's talk about what they're actually arguing, because this is where it gets slick. They say that the federal stalking statute could never qualify as a crime of violence because, wait for it, it might be violated recklessly. Might. That's the word doing all the heavy lifting. But here's the problem for them. This case isn't about a hypothetical defendant. It's about this defendant. Prosecutors don't charge stalking because somebody accidentally scared someone. They charge stalking because somebody targeted, followed, threatened, harassed, and terrorized another human being over time. This isn't oops, oh, my bad. This is intentional behavior. Stalking isn't some passive, oops, my bad crime. It requires purposeful conduct, repeated actions meant to cause fear, emotional distress, or intimidation. You don't stalk somebody by accident. You don't repeatedly show up, track movements, send messages, and create fear by being reckless. That's not how stalking works in real life, and prosecutors know that. Now, let's talk about the whole elements clause. Gymnastics the defense is actually trying to do. They're saying, well, technically the statute doesn't always require the use of physical force. Okay, and neither does robbery until the threat is implied. Neither does extortion until fear is created. Neither does kidnapping until the restraint happens. But the courts don't pretend these crimes exist in a vacuum. They look at what the conduct actually does to the victim. Stalking is dangerous because it creates an imminent risk of violence. That's the whole reason Congress federalized it, because stalking is how people end up assaulted, how people end up dead, how situations escalate, and pretending that stalking isn't violent just because a statute can be violated in a theoretical edge case is legal fantasy land. Now, let's address the Borden argument, because that's another sleight of hand. Borden said reckless conduct can't qualify for certain violent crime enhancements. Cool, but stalking isn't some drunk driving style recklessness. It's directed behavior at a specific person. You have to pick a target. You have to engage in repeated actions. You have to knowingly cause fear or distress. That's knowing and purposeful conduct, whether the defense likes it or not. And here's the part they really don't want to talk about. If courts adopt this defense logic, then federal stalking becomes toothless, meaning repeated threats, not violent. Following someone across state lines, not violent. Creating fear or doing something so severe the victims change their lives, hey, not violent. That's insane. So Congress did not pass federal stalking laws so defense attorneys could turn them into academic hypotheticals. They passed them because stalking is a precursor to real violence, and prosecutors are required to treat it seriously. So no one district court opinion doesn't erase decades of enforcement. No theoretical recklessness does not override real world intent. And no, stalking doesn't magically become nonviolent just because the defense says the word categorical enough times. This makes legal smoke and mirrors. And the prosecution's position is simple. Look at the conduct. Look at the intent. Look at the danger. Because in the real world, stalking isn't abstract. It's threatening. It's coercive. It absolutely qualifies as violent behavior when it puts victims in fear for their lives. And that's exactly why this argument should fail. Because they already pointed out that once we go ahead and add in the fact that Lil Durk then had Quando Rondo shot at in Savannah, Georgia, once we sit up here and we add that Quando Rondo has basically been shot at a couple other times that we probably don't know about, or snitches are going to come through and say all this shit, bruh, that's where we going to go, oh, damn, stalking might go ahead. So it's not really just about the one damn crime that happened in LA. It's not that at all. What it's really setting up is for the other damn acts to come in. The one with the Stephon Max, the one with Quando Rondo, Savannah, Georgia. They're trying to line Lil Durk ass up with the stalking charge because they're bringing in the other ones. But let's see how the rest of this goes. Roll it. Third, the court rejected the argument that the statute's death resulting penalty provision alters the analysis. The court held that the enhancement likewise does not require the government to prove the requisite mens rea for violent force, and therefore it cannot convert a non-violent offense into a crime of violence. Finally, and critically, the court explained that 2261A1A may be satisfied by conduct involving threats of self-harm rather than force against the person of another. Because the elements clause requires force to be directed against another person. The statute necessarily sweeps more broadly than the guidelines definition of a crime of violence. For all those reasons, the court held that the stalking offenses charged under 2261A are not crimes of violence, and that the associated 924C counts must be dismissed. Mangione confirms rather than undermines defendants' arguments in this case. Although Mangione applied the modified categorical approach, its conclusion is fully consistent with and reinforces Mr. Houston's arguments here. Even under a divisible statute analysis, the court held that 2261A1A fails the elements clause because it does not require purposeful violent force, permits conviction based on recklessness, and encompasses conduct directed inward self-harm rather than force against another. Accordingly, Mangione provides additional persuasive authority confirming that 2261A1A cannot serve as a crime of violence predicate under 924C, the precise issue presented by count 4 of the indictment in this case. Conclusion. The district court's decision in United States versus Mangione squarely addresses the same statute charged here, 18 U.S.C. 2261A1A. Hey, and I just lost my place. My bad, y'all. And holds that offenses charged under that provision are not crimes of violence as a matter of law. The authority further confirms that count 4 of Mr. Houston's indictment cannot stand. For this additional reason, and for the reasons set forth in defendant's motion to dismiss and prior supplemental notices, count 4 should be dismissed. A copy of the opinion in United States versus Mangione follows this brief. Let's get serious because everything the prosecution just said sounds tough, but none of it survives actual law. Not vibes, not fear, not real world danger, law. So the law does not bend because something feels scary. Let's start with the government's favorite excuse. Mangione isn't binding. Correct. And irrelevant, because courts don't dismiss arguments just because the case isn't binding. They dismiss them when the reasoning is wrong. And the Mangione case isn't wrong. It applies Supreme Court precedent directly, step by step with no shortcuts. That's not weak authority. That's persuasive authority doing exactly what it's supposed to do. Now, let's talk about the government's biggest sleight of hand. Look at the conduct, not the statute. No. That's not how this works. That's not how it has ever worked. When the government tries to label something a crime of violence under 924C, courts are forbidden from looking at the facts. Forbidden. When they must use categorical approach, which means one thing and one thing only. What does the statute require at its minimum? Not what happened in this case. And the government knows that. So that's why they keep on saying real world danger instead of statutory elements, because once you read the statute honestly, their arguments die. Now, let's read the statute honestly. 18 U.S.C. 2261A does not require physical force, attempted force, threatened force, not even close. So you can violate the statute through monitoring, surveillance, communication, emotional distress, no punch, no weapon, no violence, and the Supreme Court has been freaking crystal clear. Fear is not force. Distress is not violence. Risk is not an element. The elements clause does not care about what might actually happen. It only cares about what the statute requires. And this statute does not require force. Now, the prosecution tries to save itself with this line. Well, stalking is intentional. Again, wrong question. The Supreme Court already answered this in Broden versus United States. Intent to harass, intent to use force, intent to cause emotional distress, intent to commit violence. The statute explicitly allows conviction without purposeful or knowing intent to use force. That alone killed the arguments clause. And here's where the government really gets exposed. They say accepting this defense argument would gut the stalking statute. That's emotional manipulation. No one is dismissing the stalking charge. The defense is dismissing count 4, the crime of violence enhancement. Congress chose to write 226A1 broadly. Congress chose not to require force. Congress chose not to include violence, a violent element. Courts don't fix congressional drafting by stretching statutes beyond their text. If the government wants stalking to be a crime of violence, they can. Charge threats, charge assaults, charge weapon offenses. What they cannot do is relabel nonviolent conduct as violent after the fact. That violates due process. And finally, this idea that stalking is inherently violent, that's not logic. That's not rhetoric, pardon me. Plenty of crimes are dangerous, right? They're terrifying, they destroy lives, but the Supreme Court has been ruthless to this point. Danger equals violence, escalation equals force, possibility equals statutory element. And that's why Mangione matters, because it does exactly what the courts are supposed to do. Apply the categorical approach, follow Supreme Court precedent, ignore emotional pressure, enforce the statute as written. No hypotheticals, no fear-based arguments, but they're hitting it with the what if. If the government wants to win on that narrative, the defense wins on law. And when you apply the law correctly, count 4 cannot stand. Not because stalking is a serious, but because serious does not equal violent under 924C. And that's the end of it. The defense is technically about to throw out something that's going to require a mandatory life sentence. And that's the part where the feds are pissed off, because the feds is like, we're not going to kill them, so we're not going to seek the death penalty here. Well, damn, they might actually, meaning the rest of OTF and Lil Durk, say they lose this case. Man, they might only get 30 years. They might get 40 years, but they're going to get a release date. And that right there, Lil Durk getting out at 50 years old, well, no, cuz it's in his 30s. So Lil Durk getting out at 60 or 70, something shit like that. Man, look, I'm not saying that he's going to lose the case. And I'm not saying that all these cats is guilty, because hell, if I know, I wasn't there. But what I am saying is this. If that Mando life gets taken out, and y'all already said y'all not going to kill him from the Fed standpoint, then what the hell are we doing? We're going to start seeing plea deals get off for like, hey, bro, if you plead guilty here, you plead guilty here, we'll give you 25 years. We'll possibly give you 20 years. And we'll say, you got to serve 85% of that. And y'all can do the math on that one. This right here is the big ass W, even if found guilty, because you're not going to spend the rest of your life in jail. Possibly. That doesn't mean that, they won't get life. That don't mean the judge won't, bam, slam the shit out of the guy and go, life. It doesn't mean that at all, but it definitely does help take out the mandatory life and possibly serve for a lighter sentence. But y'all, let me know y'all thoughts on this one, man. I did enough explaining. I think I did all right with this one. If you think I did, man, hit that like button like you like some, comment your thoughts. And we are 26K away from that giveaway. So this right here and this right here, those are the giveaways we're doing around the 300K subs. Yeah, it is what it is. Click right here. I forget the video that's going to pop up, but shit. I don't know. I forget the video, but click right here. Click right here. No. It's about how they lied on 21 Savage. The industry trying to destroy 21 Savage. Click right here to see exactly how I destroy that bullshit narrative. Click right here for the playlist, and I'll catch you on the next one.